Give us 30 minutes each week to discover the trends that are shaping the future of retirement with That Annuity Show. We bring you conversations with industry leaders who are revolutionizing financial products, technology, and distribution channels. Now, here's your host, Paul Tyler.
Hello, and welcome to another episode of That Annuity Show. How are you doing, Mark? Welcome to the show.
Teresa, I'm great. Thank you. How are you?
Great. We're finally getting some steamy summer weather here on the East Coast. So looking forward to some warm and sunshine.
Been a long time coming.
Definitely. It's taken some time to get there, but we think we're into summer finally, hitting June. Eric and Kent, welcome to the show. How are you doing today?
Great. Thank you.
Very well, thank you. And appreciate making my debut on the That Annuity Show.
We're very happy to have you on the podcast today for sure. So welcome. Well, I'll have Mark formally introduce you in just a sec. But before we do that, wanted to just introduce our topic for today. We're going to be, discussing the most recent and latest DOL ruling regarding fiduciary responsibility. This is a topic that our show, That Annuity Show, has really kept you all up to date, our subscribers up to date over the years. It's been a multi-year, drawn-out process, given the operational, financial, and other impacts it would have to our industry and all of our stakeholders. So while the lawsuit has formally been dismissed and guidance withdrawn, we wanted to talk about, what does that all mean? What does it mean next, if anything, and just break down the latest in the process. And as I said, we've got some great guests here today who have been very, very close to following all that and influencing today's the outcome. So we're excited to have them here to break it all down for us and give us their insights. And with that, I will turn it over to you, Mark, to introduce.
Thank you, Tisa. We couldn't have, I think, two better guests who will help walk us through this today. We have Eric Marhoun and Kent Mason. Eric is senior counsel with Nassau Financial. Eric and I have known each other for quite a number of years. He's held similar roles with other carriers and has been a long-time industry advocate over the years that has really helped change the landscape of our industry. And Kent is a partner with Davis Harman. Davis Harman represents major employers, large plans, and plan administrators. So they really view it from two different perspectives. So I think it's going to be a great conversation today to really hear from both of them, how we got to this place, what it means for the industry, and what it means going forward from a producer standpoint. So Eric, why don't I kick it off to you for a little backdrop, if you will, in terms of how we got here.
Wonderful, and thanks for the opportunity to be here, especially on such an esteemed panel with Kent Mason. It's interesting, in sort of setting this up, people have asked periodically, what is the intent of the Department of Labor relative to expanding the definition of fiduciary? And that's what we're talking about here, just to be clear, is we're talking about Department of Labor efforts to impose an ERISA fiduciary duty on retail securities and annuity transactions, primarily rollovers. It's important to keep in mind that brokers and insurance agents operate under a best interest standard that has been adopted quite widely and now really universally since 2020. But what the controversy and honestly litigation focused on were attempts by the Department of Labor to assert its jurisdiction over what was generally not considered to be sort of true plan ERISA advice and recommendations. And Kent will provide a better sort of context on that because he looks at it from the overall perspective of being an ERISA attorney. I come at it from a different perspective. I'm an attorney that counsels investment advisors, broker-dealer reps, and predominantly, over the last 20 years, independent insurance producers. Many of them are also brokers or investment advisors, but the reality is that now they're all subject by regulation in one form or another to a best interest standard. And I think when they announced the first full-blown rule that was more than just a proposed rule in 2016, I think the secretary at the time, Tom Perez, probably as much as admitted that in saying the retirement market has changed. It used to be predominantly ERISA plans were defined benefit plans offered by employers, but now there are qualified plans that are self-directed, that people have choice within, that come about through rollovers, IRAs. You're actually dealing with a plan where people are within a plan and they really don't have that much control over it, choice over it. It's sponsored by their employer, particularly if it's a defined benefit plan. It's even managed by them. But this all started a little bit in 2010. There was a proposed fiduciary rule, and people were really concerned about it and saying, this is really going to make the marketplace overregulated, overly burdensome, and limit choice to consumers. And so it was pulled back. It was never formally proposed, I believe. And Kent will correct me if I'm wrong. And then a rule was adopted in 2016, immediately was subject to litigation. And by 2018, that rule that had been promoted by the Obama administration and Secretary Perez was wholly overturned by the Fifth Circuit Court of Appeals based on oral argument held down in New Orleans. And that case is called the Chamber of Commerce versus the Department of Labor. And an odd thing happened right after that, because that basically restored a regulation that has provided clarity and drawn a sharp and good line for years since 1975, called the five-part test. And I'm not really going to go into that test. It's odd how a lot of people now have heard of that because it's affected us. It's pretty funny. A lot of agents could probably tell you, that old five-part test. But that had provided clarity over 40 years in the retirement market. And that was restored. But in 2020, in December, at the very end of the Trump administration, I like to say speculate, unlike Kent, I can speculate more because I'm not bound by knowledge, that the deep state basically, in the waning days of the Trump administration, completely reinterpreted the five-part test and then went through a 2-year implementation process. Everybody was up in arms. Everybody pushed back. But in the end, 2 trade associations sued, one called the American Securities Association, which sued just over a part, but an important part of that rule, that guidance called the 2020 guidance, and then the Federation of Americans for Consumer Choice, who we are a little more aligned with, members of, advisors to. It challenged all of the guidance itself, all of the reinterpretation, because basically what the reinterpretation did is it just took every word, changed its meaning, so that suddenly something that allowed for rollovers, allowed for more individualized retirement advice for people leaving plans was subject to all sorts of ERISA requirements, which unfortunately also include the possibility of third-party litigation. So FAC brought its lawsuit, and before that was even fully adjudicated in 2024, the Biden administration, in my view, basically reinstated the 2016 rule. They used different words, but to me, it just had the same result and sort of the same animus. And so there was a bunch of litigation. And kind of long story short on the litigation, FAC brought a challenge against the 2024 Biden rule, seeking preliminary injunction. The American Council of Life Insurers led a coalition of associations that also brought an action for preliminary injunction, and the court granted it, and there was a partial ruling at the same time, somewhat in both the ASA case and the FAC case against 2020 that really kind of gutted the biggest part of that interpretive rule. But there, things were on hold for about 10, 11 months until this administration finally cleared the decks. The parties in the 2024 cases entered into an unopposed judgment, and the judgment vacated the 2024 rule by operation of law. And as to the 2020, the Department of Labor looked at all the litigation, all that had been said, determined, and completely withdrew the 2020 guidance, other than retaining what's called a PTE, which isn't applicable to independent agents, so I'm not going to touch on it. Kent might. And so with that, the world, in my view, was kind of restored again to what existed before 2016. Including, and I'll let Kent talk about this a little bit, reinstatement of something called the Deseret letter, which provided some clear guidance that one could provide rollover advice as an agent or a broker. And what was interesting to me a little bit about this is particularly these last 4 years, 2020 to 2024, where there was all this overreach by the Department of Labor, was occurring at the same time. The insurance industry and the securities regulators were fully adopting respective best interest standards. Kent has the best view on how those can be different from an ERISA fiduciary duty, but I always find it ironic that even as industries, regulators, functional regulators, consumer groups are coming up with better regulation that still allows consumer choice, but protects them, protects consumers.
So in a sense, over the years, the different iterations, I mean, I think everybody is obviously in agreement in terms of doing what's best for the consumer, right? Doing what's in their best interest. It's really, in a sense, who and how that governance is going to take place and the processes and documentation behind it to support it. But at the end of the day, the best interest has always been what's been important, front and center.
Yeah, and Kent will also give us some insight into how different they can be, this ERISA fiduciary duty and both best interest and other fiduciary duties.
Great.
Yeah.
So now you're all on pins and needles waiting to get the real answer. You're like, we just got a bunch of speculation. Thank goodness there's someone here now to give us real answers.
Well, thank you. And I want to thank Eric for his leadership. I mean, he's understated his critical role in the litigation that's happened, that's gotten us to this point. So thank you to Eric for leading the charge on two different pieces of litigation, both the 2020 preamble problem and the 2024 fiduciary rule. I think, Mark, your question, we all agree on a best interest standard. And so one of the questions that's posed to us is, well, why was it so concerning? Why was this fiduciary rule so concerning? It was just framed as, we're just asking you to act in the best interest of your client. And we all are dedicated to acting in the best interest of our clients. So why was this such a problem? Well, the problem was that's not what the rule did. The rule had two pieces. One, which said you have to act in the best interest of your client, which was never a problem. But the second piece was, even if you act in the best interest of your client, you can still violate the law if your conflicts of interest are too great. Well, what are conflicts of interest? One conflict of interest in their world, I'm not saying in mine, but in the department, commissions are a conflict of interest. Because if you trying to sell a product and you're going to get a commission if you sell it, you've got a conflict of interest that could prohibit you from being the right person to give the advice. Another conflict of interest is in rollovers. If you get the rollover, you make money. If you don't get the rollover, you don't make money. That's a conflict of interest. Okay? So I think we, sort of the industry, don't have a concern with saying that our advice with respect to buying a product where we get a commission or making a rollover, we agree that advice has to be in the best interest of the client. We have no concern with that requirement. But essentially what the Department of Labor said is your compensation structure doesn't work because it creates too big a conflict of interest. So even if you act in the best interest of your client, you can still violate the law because of how your compensation structure works, because it gives you a conflict. And so we're not really trusting you to give advice on rollovers because you have too big a conflict of interest. We're not going to trust you to give advice on purchasing an annuity, recommending an annuity product, because that gives you too great a conflict of interest. Well, that is a direct attack on what we do for a living in terms of, selling insurance to people who need annuities to people who need them, and giving opportunities to roll over to people who want to take advantage of the insurance products that are available through a rollover. So that, to me, is the core point and explains sort of why this was such a problem and why it was correctly invalidated. Because it was just saying this whole business model, which has worked very well to help individuals get protection, is just not acceptable to the Department of Labor. Well, it's acceptable to the courts, it's acceptable, to the government, it's acceptable to consumers, and unfortunately we're back where we should be.
Great. So I see how problematic and disruptive anything going in that direction would be, to your point of how our industry works, the models that do work, and the challenge would be to shift and manage anything different as far as recommendation and commission. So the latest ruling, as I understand it, we believe cements the DOL's position on this issue. So we know that that's rear view, less immediate disruption, right? Threat of immediate disruption. Existing rollover practices are going to remain intact. Are there any other operational considerations or other considerations for advisors now that we're looking forward? pass this ruling?
I mean, I think I think thanks to a lot of people's hard work, I think what advisors can be doing is continuing to serve their customers the best way they know how. I mean, it's really important that you document, why the advice you're giving you believe is in the best interest of your client. That is still critically important. But that's just doing what you believe in. You believe in your product, you believe in the services that you're providing, and you need to sort of understand why those products and services are in the best interest of your clients. Now, I think Eric did say under some narrow circumstances, you can be a fiduciary. And the way I would summarize that 5-part test very briefly is if you are, and this is why we can illustrate this in the rollover situation. I'm going to oversimplify a little bit, but you're going to be a fiduciary if you regularly give advice to a customer with the understanding that the customer is going to rely on it. So if every time you give advice, the customer sort of says, that I trust you completely. You just do what's right. Give me advice, check in with me, but I'm going to follow you every time. Those are situations, and that goes on regularly, then you can be a fiduciary. But what you need to emphasize with your clients is they need to critically analyze what you're recommending. That they should not be rubber stamping what you're saying, because it's really important that they make the decision on their own. You can give them information, you can give them the pros and cons, but this is their decision. They should not be sort of just blind allegiance to your advice. And so document that you think it's in the best interest. Also document that you've really given them the tools so that they can make their own independent decision. That's the path forward for me.
And Tisa, if I can be a little more granular or supplemental to that, because you asked, what does this mean going forward now that we're I did a presentation, I called it Back to the Future, but it's really back to the past, which is how we operated for 40 years relative to rollovers. But I think it's really important to emphasize that the current regulation on the insurance or the security side, as an agent, broker, advisor, you need to take it seriously. Yes, we have beaten back some of this unwarranted overreach by the federal government, but there are requirements relative to satisfying the best interest under the insurance regulation. Companies help in that. Yes, sometimes it's paperwork, it's forms, and agents need to know that should be taken seriously, and it's more important than ever to really embrace this new best interest regime, because it's part of why we really were, I think, able to justify why it made sense to challenge the Department of Labor. Now, what's ironic is, and maybe Kent will have a view on this, the Department of Labor didn't seem to give us any credit at all for developing best interest standards, either in the securities industry or the insurance industry. But that doesn't mean we shouldn't take them seriously. We shouldn't strive to adhere to them and follow them. In addition to sort of the intuitive historical context that Mark noted and Kent's talked about, which is, act in your client's best interest as part of the relationship you have. But we do have this framework now, and it's important to follow it.
Yeah, I totally agree with you. And that's helpful, I think, from the advisor lens or perspective of what they need to remain, being mindful of and what still applies, which is always pretty much applied to your point. What about from the carrier or the company perspective? We know, their obligation or our obligation for supervision remains. Any considerations for carrier, sort of that different perspective or lens for them?
Well, I think, it's making sure, and I think carriers are devoted to this, we're available
Absolutely.
to help agents meet their requirements. We all have, very robust suitability processes that now we've just kind of expanded how they operate relative to quality of business and the new best interest requirements. And it's a matter of trying to be clear, why do I have this form? Why do I have some of this documentation? And technology helps with some of that. If I were an agent, whenever I could do an electronic submission, I'd do an electronic submission. The electronic submission is the best way that the insurance carrier captures, did you satisfy all of those things that are required under the regulation? it isn't a manual check of a paper form coming in or documents coming in. You really can't proceed until you've satisfied those. And I believe more and more agents are embracing that. I don't have the figures for us, but I think the figures are incredibly high as to how many of our agents now, all the business is submitted electronically.
Yeah, I mean, it is very high adoption, and it's adoption that we've driven over the years. But to your point, it's kind of that combination of explaining the why it exists and what it means, but then, okay, you need to do this. Let's make it easy and efficient and straightforward and remove that friction for them to do that, so we can save them time and make sure everything's covered. And so in our case, and I know it's the standard across the industry, most offer some form of an e-app process, and it does have all the logic and all those rules and all those checks built in, and it's really designed to obviously adhere with what we need to adhere to, but make it easy, kind of take the thinking out of it and make sure everything's covered. So good point on the way technology has helped support those supervision or supervisory obligations as well.
Now, I did want to ask Kent one technical question, just because, agents see some of this in the trade press and wonder what it means. And that is, yes, we are back to the landscape of 2015, prior to 2016, and that includes something called the reinstatement of the Deseret letter. And I know Mark stays up at night reading that and understanding that. But maybe you could share a little, because I do deal with a lot of agents who say, yeah, I understand that was important, but they're like, I'm not a practicing lawyer. Why do you guys care so much about that?
Sure, happy to talk about that. What that letter says, and this goes back to the question of when you are talking to a client about rolling over their assets from, say, a 401k plan to an IRA where there's an annuity product embedded. The question is, are you a fiduciary in giving that advice? And I think the invalidation of the 2024 rule helped a lot in saying, generally, no, you're not going to be a fiduciary. I think the invalidation of the 2020 preamble helped a lot. But the reinstatement of the Deseret letter was sort of the final piece, because the Deseret letter says very plainly, if you, the advisor, are not already a fiduciary to the plan, then your advice to the participant to roll over from the 401k plan to an IRA is not fiduciary advice. So any advice you give, you can say, I really think this is, the best thing for you is to roll over from this plan to this IRA. And even if you've been giving advice regularly to that person, outside of the 401k plan, you're not a fiduciary to that plan. And therefore, your advice to roll over is not fiduciary advice. And that's just a nice categorical resolution of this uncertainty, or this, which sort of, how do you stand? Where do you stand when you're giving rollover advice? And the answer is, you're not a fiduciary unless you are already a fiduciary with respect to the plan. And very few of the agents out there are already fiduciaries back to a 401k plan.
Yeah, and just to kind of put a fine point on it here, we're really talking about being an ERISA fiduciary. And
yep, absolutely.
And that's a sole interest standard. Kent can talk a little about that. But certainly best interest has aspects of a fiduciary standard. People who are truly investment advisors are subject to a certain type of fiduciary standard, but it's not an ERISA fiduciary standard. And I'll let Kent talk to that a little. I do want to emphasize, again, one of the problems is when you are a ERISA fiduciary is you're just subject to second-guessing litigation by people, in my opinion, who aren't your regulator, aren't experts, aren't, for example, insurance commissioners. Mm-hmm. And we all know, that's always part of why you have, as Mark has emphasized here, good documentation is for regulatory purposes. But when you're dealing with litigation, you almost never can have perfect documentation because it's always, used against you.
Yeah.
And it's an important thing to kind of keep in mind, what does it mean to be that ERISA fiduciary? Because people who actually satisfy that standard have to go through a lot. And so much so that I don't think it'd even be practical for access to, individual retirement products.
Yeah, that That clarification definition is helpful. I wanted to switch gears a bit, and I know both of you had roles, in this outcome. I know that we had our, I'll say industry organizations also playing a role. You're both very active in FAC and NAFA and some others. Can you just maybe talk a little bit more about that, the role of those organizations, and also, currently, but just more broadly, sort of the importance of them in, I'll say protecting and moving us in the direction as an industry collectively.
Yeah, I think there's a lot of, I don't know if synergies, consensus, what the right word is among the trade associations right now. The 2020 guidance was, I think, and it'd be interesting to get Kent's perspective, a real eye-opener for industry. Because there were people in industry who thought, it might be good to have some guidance from the Department of Labor. And there were other people who said, including myself personally, no, it won't. That guidance will either not be clear or it will expand their authority, because that's just what the staff does. And the staff will wear down the leaders, as it always does. And so 2020 came out and all of the industry woke up and said, this is horrible. This is terrible. But they didn't know, some of them just didn't know what to do. A lot of the industry felt, this is terrible, but we're not sure what it means, and until there's actually active enforcement actions, how can we challenge it? Well, FAC, the Federation of Americans for Consumer Choice, and the American Securities Association were among the most proactive in saying, wait a second, we don't need to wait for an enforcement action, because we all try to comply with what we think applies to us, and the Department of Labor is saying, this is your new world. So FAC exercised some leadership, but some really important trade associations were a big part of the 2020 challenge as well. The American Council of Life Insurers submitted an amicus brief. The Hispanic Leadership Fund, represented by Kent, submitted an amicus brief, and I'll let him talk more about that. So I think some learnings came out of 2020 that the industry as a whole was very fortunate that ASA in Florida and FAC in Texas brought these actions, and realized in some respects they kind of dodged a bullet because of the litigation brought by these leading trade associations. And that's why now I think you see more sensitivity, and you saw a lot more activity, action, energy, leadership when the 2024 rule came out. And a lot of that credit, in my view, goes to the American Council of Life Insurers, because they led one of those challenges. They pushed for a preliminary injunction, as did FAC. And right now, I think the industry is looking and saying, this is great. We've come to a point where we have some clarity. And, we're hopeful that the industry will realize our focus now needs to be on, let's make sure we're fully implementing best interest. Let's make sure we're sticking to our knitting. We don't really need a bunch of people knocking on the door of the DOL saying, oh, we're confused. Why don't you do something?
Great. So Ken, I just wanted to follow up on what Eric just mentioned in your role in the Hispanic Leadership Fund and the study that they had conducted. I know that study demonstrated that there would be a lot of concern if this ruling had turned out differently, impacting middle income families. Can you just speak a little bit about the study and your ongoing role with the fund?
Yes, thank you. I think that the primary point that we wanted to identify was the fact that in the media, if you look at the media coverage, they seem to equate a broader fiduciary rule with helping low and middle income individuals. They say, gee, if we sort of have a stricter rule that makes more people fiduciaries, that's going to help low and middle income individuals. And it has been so difficult to show them that that's wrong. And so we worked on a study, and sort of sponsored by the Hispanic Leadership Fund, which put the issue to the test. And let me sort of, before I describe the results, let me just describe the problem. And that is that financial institutions don't make money on small accounts. In other words, if there's a $3,000 IRA, that financial institution is losing money on that. And so the question, so why do they deal with them today? I mean, there can be a variety of reasons. I mean, such as, this $3,000 account may at some point grow into a bigger account. We're looking for the future. There's also sort of it's good for the system to have, more people engaged, even though we're not making money on every single person. But what happened is that the Department of Labor rule would have made serving those all accounts much more expensive and much more risky. So the analysis just completely changed. Before, you were losing a little bit of money on the $3,000 account. Now you'd be losing a much more material amount of money on that $3,000 account. And so there was widespread evidence after the 2016 rule came in that financial institutions were dropping their small accounts. And so they were not getting served. And so when we heard that the Department of Labor was looking to revive its rule under the Biden administration, we worked with the Hispanic Leadership Fund to do a study to say what would be the effect of reinstating something like the 2016 rule, which they ended up doing. And those were very, very stunning conclusions. Not stunning, but stunning to the proponents of the fiduciary rule, because they showed that over a 10-year period, people whose earnings or income is less than $100,000 would lose $140 billion from their savings because they were not getting the advice they need. And advice is important. I mean, left to your own devices, just think about it. You read every day that the market's going down. You're worried. You kind of say, I've got to sell. And you sell at the bottom. Or and so, you're going to make mistakes, or you hear about a hot fund and you run over to that hot fund and the hot fund's finished its run. So you bought high and you're going to sell low. So advice matters. And so if you get dropped by your financial institution because your account is too small, that's bad for you. And that cost $140 billion. And there was also a special sort of attention in that study to the racial wealth gap. And the racial wealth gap was estimated that if the fiduciary rule came back, would increase by 20%. So this is a social issue. It's a social challenge. And the people who say they're doing good were actually doing the opposite of good.
Yeah.
So that was the study. It had a real big impact. It was cited continuously in this debate. I was very proud of what the fund was able to do. The fund also participated in amicus briefs in the 2024 challenges, both the challenge by FAC and by ACLI, as well as participated in the FAC's challenge to the 2020 preamble. So I give a lot of credit to the fund. I mean, I also want to echo what Eric said. The trade associations have worked together wonderfully. Mm-hmm. And, particularly on the 2016 rule and the 2024 rule, on the 2020 preamble, the heroes of those stories are the American Securities Association and Eric and his leadership with the Federation of Americans for Consumer Choice. So overall, though, it was just a wonderful joint trade effort.
Yeah, that's such a great example in terms of the work that you guys do in terms of helping to bring perspective to things. So if you think about, the objective obviously was clearly intended to be a positive in the industry, right, with this ruling, yet there's these unintended negative consequences that they may have not looked at that ultimately hurt certain segments of the market. And, without the work that you're doing, showing the big picture, I think that really helps keep the check and balances in place in the marketplace.
Yeah, I agree. Thanks, Mark. So before we start wrapping up, we want to make sure we leave our listeners with a few practical takeaways. I think we've already given them a few, but, regulatory movement will continue, right? We've seen it. We know it will continue, but we just don't know what. And so I think, as we've stated a few times already, being mindful, right, of the trust that clients put in advisors. We know that clients need that advice. And advisors are here to serve their clients every day. Wanted to ask, any kind of final questions, Mark, that you might have for our esteemed guest today as we start to wrap up today's episode.
Yeah, thanks, Lisa. This obviously is an industry that evolves a lot over time. And I guess one question is, we've seen a big movement in AI, right? And a lot of different ways people are getting access to information and even recommendations from technology. What are some of the things you see on the horizon that we should be keeping an eye out on going forward?
Well, I think, AI, is being embraced by a lot of agents and advisors because, as you just alluded to, Mark, It's one way to help them discern through the choices that are in the marketplace what's best. But I also think it has a role in helping them comply with the best interest regulation and help as they articulate what their recommendations are. So I think it's going to continue to be a boon, and it's something we've embraced here within some of our operations as well.
And Kent, how about from your perspective?
I think my sense is Eric is going to be closer to this issue than I am. My advice would be it's a valuable tool, but it needs oversight. I have used it and I found it very useful. And at times I find it needs a little work, a little human oversight. And so, I think that my only 2 cents would be to use it, but use it with your own oversight and human judgment, because ultimately you are the one responsible.
Yeah, and even from the consumer perspective, right? Like, are they going to try to rely on it from their own guidance and start trying to make decisions on their own without looking at the big picture, right? Because you can look at one specific scenario and that might not be what the right solution is based on their overall picture. So it'll definitely be something to keep a close eye on. Eric, any closing thoughts in terms of where you see the industry headed?
I continue to see the industry developing, offering more options for consumers. And that really was a little bit at the heart of all of this challenge and litigation, because regulators often, and I think this is true in spades of the Department of Labor, they're more comfortable with limited choice. And what advisors and clients need is more choice. And I think we're going to continue to see that, but it is going to be subject to the appropriate level of supervision. And if it has this good best interest regulation framework.
I guess I don't want to be a downer, but there is a downer little point to be made, which is I think that there is amongst the proponents of the fiduciary rule, the 2024 rule, there is significant unhappiness that they did not believe, and I don't know why, the Hispanic Leadership Fund's analysis. It's just hard to be sure. So, but certainly, I think the signs are some people speculate this Department of Labor could revisit this issue during the next 2 years. I do not see that happening.
All right. So we may have closed the chapter, but we haven't finished the book.
Good. Thank you for all of those points. It's this chapter, to Mark's point, right, is done, but the book is not closed. We have some idea what the future holds, but we have, no crystal ball by any means. So what we can anticipate is a ever-evolving regulatory landscape and shifts in our industry, both, business practices and consumer expectations and behaviors. So I think what I heard through all that we talked about, the core remains the same, having sustainable practices, doing right by customers, keeping sound documentation. Maybe AI can help on that front, a little note-taking, but ultimately we know the roles that you all play on the legal expertise side, and the trade associations and others are all really beneficial to protecting ultimately the clients. And I think that's where we agree, right? Carriers, advisors, and our government, I think ultimately are, intending to protect the client. So thank you for the great discussion today. Mark, I wanted to give you an opportunity for a final thought, and then we will close out the show.
I wanted to just, number one, say thank you for your insights today, gentlemen, and also thank you very much for all you do for the industry. You really help guide and navigate the landscape. So we appreciate everything you do.
Thank you, Mark.
Great.
Thank you,
Kent.
Thank you all.
Thanks, Kent, and thanks, Eric. Thanks, Mark, for joining me today to host this episode of That Annuity Show. And we hope to see you again in the future for another episode of That Annuity Show. Thank you.
We seek to keep things simple and have your back in the years to come. Nassau is headquartered in Hartford, Connecticut. Learn more at nfg.com.
Zinnia, an Eldridge Industries business, simplifies insurance. It delivers comprehensive solutions for the industry's most critical needs and creates the modern rails of the insurance industry. To learn more about Zinnia, please visit zinnia.com.